Welcome back to the channel, and thank you all for watching HCKT TV. Make sure you visit Everett, Kentucky. That's my hometown and the hometown of heroes. While you're visiting Everett, stay at Black Mountain Cabins and Campers, located there in Everett, Kentucky, just minutes from the trailhead. Also, while you're in Everett, eat at the Southern Belle Restaurant, located in downtown Everett. Also, if you support the channel, scan that QR code. Let's get started into this video. Thank you for watching. Where is the transparency at, Mr. Government? I can't see it. The Black Mountain Off-Road Adventure Area has released a 2025 riding schedule, so please come to Harlan County and ride with me. I hope to see you there. What is going on, everybody? Welcome back to the channel. I want to thank y'all for watching. This is a court case out of Arizona, Judge Roberts Court. I don't know what this man was charged for. I don't think he's a sovereign citizen. Could be, but I don't think he is. But he seems like he's getting railroaded in court. I want y'all to really watch this video. Watch it to the end. Watch what the man says to the judge. It's just wild. I mean, he's not even got his motion of discovery or nothing. I mean, from what he's saying. Anyway, check it out. It's coming from Judge Roberts Court in Arizona. Y'all, it's amazing. Just check it out. Watch it.
We talked about that last time, and I told you last time that I wasn't going to give you an answer on that until I got my discovery, which I still haven't got. I put in motions about the discovery, but I guess you want to wait till after you try and railroad me and push a lawyer and speak for me. I want my discovery. I want that 6 months set, and and I want those motions to be, because there's no reason that I should be here in this courtroom being railroaded by you guys. Let the record show that the judge never looked at me or acknowledged anything that I said.
Rules of evidence said something.
I'm not signing anything you give me. Yeah, I don't agree to anything that you say or anything out of this corrupt court. Okay. So go ahead and save your ink and your paper, because I don't want it. I'm not signing it. That's what you want. And if you think you're gonna force something on me, you've got to understand, Judge, I'm innocent. Right? This shouldn't even be going to trial. This is
What I've done is printed out a waiver of attorney form. It's been filled out already. If you don't want an attorney, you can sign the form and then we'll move on.
I'm not signing anything, I told you.
Do you want an attorney or not?
I'd like to know what's going on with these
Let me
motions.
rephrase that. You've already indicated to me you don't want an attorney, so for the record, I'm going to indicate.
No, I told you I don't want you speaking for me, that I never said that. See, there you go speaking for me again. I need a new judge. You're a bad judge.
Okay.
You're speaking for me. Stop speaking for me, because what you have to say and what I have to say are completely different things.
I'll tell you what we'll do. Why don't you
recuse yourself?
Why don't you go ahead and address your motions? They've already been ruled on, but go ahead. Start in order that I presented them to you.
Presented what?
You saw the minute entry.
You haven't given me anything.
There was a minute entry entered on your motion.
I haven't got anything.
It was mailed to you. It was issued on. Let's take a look. March 20th, 2025.
And I haven't got it.
Can you print him a copy of the minute entry?
Thank you.
All of those.
And what is your rule on those?
Well, you can read it for yourself. In the meantime, while we're waiting that for me printed out so you can read what I've already done.
I'd rather you tell me instead of making me have to guess, right?
You're not going to guess. You're going to read it for yourself. Meantime,
no, I want you to explain that, though.
Well, you have.
I already know that you're trying to railroad me. You're not trying to let me out of this court.
All right.
You know?
So, and the end result is today. Do you want me to set a trial date or not?
I've wanted you to do that from day one. Is it going back all the way from day one? Is it going back from day one?
Is what coming back? I'm going to set the date for you here today.
The 6 month. I want my right to. I've been asking for that since the first day I came here.
How about May 16th?
How about
9:30
How about we do it from the day that I came in?
May 16th is your trial date. How's that? That's,
The state does not have a conflict with May 16th.
alright, we will set the trial date for May 16th.
Let the record show that the judge is setting the trial date and I haven't even got disclosure or discovery or anything.
Well, we established at the first hearing that you did receive electronic disclosure.
Well,
We're waiting for
what is-
written disclosure, so.
Sorry, if the state didn't make a record, Your Honor,
Sure.
Bagger, the assigned prosecutor on the case, emailed Mr. Gonzalez on March 3rd and April 9th with information on how to obtain electronic disclosure from our office.
I'm not asking for electronic disclosure.
Please don't interrupt her.
Who's asking for electronic, have I asked you for
Please
electronic
don't
disclosure?
interrupt her. Go ahead.
We have no record of him attempting to download or obtain disclosure electronically via Justice Web, which is the system that we use. We also have no record of him contacting our office for assistance with obtaining the disclosure. The state is prepared to set for trial, but if the defendant does not obtain his disclosure, we still intend to go through with the trial.
Well, I want my disclosure and that's the simple fact right there, is because you guys are tracking to see if I'm doing it or not. I can't do it and I haven't been able to do it, and that's what I've been saying.
So
And I want my paper copies, plain and simple.
what
Let
we
the record
acknowledge,
show that I'm asking for my discovery, and I've been asking for my discovery, and your guys' little record thing that you guys do is garbage and stuff like that. I want paper copies, plain and simple.
and you don't have to say for the record, everything we say is on the record. The, at the last hearing, you acknowledged that you had the link for the materials.
But I haven't been able to get into it, and I don't have service, let's put it that way. I put in a motion for copies, man. And I told you that I wanted copies in, and you guys tried to push this on me, like you keep trying to push
Do you
it
have a copy of my ruling now?
Motion to.
Provide him with a copy. Alright, why don't you turn to page 2, look at number 6, and Ms. Theobald, did you see the minute entry I entered on March 20th?
Apologies, Your Honor, let me go through the file. I'm suffering from Mr. Bagger today.
Yeah, well, I understand that. If you take a look at it, you'll see that what I did was,
I don't see it.
in defendant's motion number 6, which is paper discovery, I wrote, the prosecuting attorney sent disclosure to defendant via email, the most common method of delivery. Because there has been no objection to defendant's request, the court grants defendant's motion for paper copies and orders the prosecuting attorney to provide the defendant with paper discovery and any videos or photographs on DVDs either by U.S. mail or by hand delivery. Obviously, they're not here today, so we will work on that problem. You don't see that we have. So I've already granted your motion for the paper, and you will get that material, so we will make sure that you get them. So,
Well, I think I need adequate time, don't you, Judge, instead of just trying to reel me into a.
I'm trying to provide you with the speedy trial that you wanted, so.
You're trying to do everything you can to mess me over.
If May 16 doesn't work.
No, how do I have enough time to do that? Do I get enough time to interview witnesses, or I don't get that opportunity here? It
You
is.
can have,
That's
How
not
much-
right, that right don't.
how much time do you want before trial?
The 6 months, before my 6 months, I wanna be able to get my discovery, I want my interviews, I want all that stuff. I mean, I don't know what you're thinking, we're just gonna just fast track this or what?
Well, you wanted a speedy trial.
I want a speedy trial, but I want a fair and unbiased trial, Judge, which I'm not getting in this courtroom, which has been pointed out.
How much time do you need, do you believe?
I want a different judge, I want a different court, I want, everything else besides you sitting in front of me.
Okay, now, going to my question, how much time do you need to set the trial?
I have a right to a speedy trial. How long do you think I could get my interviews and my witnesses?
I'll set it in July, is that enough time?
How do I go about getting my interviews and my witnesses?
You want an attorney? You can ask your attorney that, I
Oh,
can't.
but I thought you were my attorney, well, you're speaking for me.
Okay.
You
So
can't
you
answer
want an
questions.
attorney or no, you don't?
I want a different judge. I think you're the worst judge I've ever been in front of. I want a change of venue. There's conflict of interest here, Judge, and you know it, and you're still trying to keep me here to railroad me into this charges. Show me the crime. There's not even a crime that I committed. I don't even know what you guys are trying to get me with because I don't have discovery.
No, I didn't charge you with a crime. So if July is not enough time for you, how about August?
How about I get it. How about, let me think. I want my discovery and I want to interview my witnesses. How about that?
I'm gonna set the trial date for August 7th at 1:30 p.m. And if that time does not work for you,
Is that for May? Is that from a couple of months ago whenever I came in here?
August.
When did I come in? When was my first day that I seen you and you insulted me?
Back with us?
Yes, apologies, Your Honor. I just got the minute entry right now that was not in my file. I do apologize. We will get the paper discovery.
And who am I talking to? I don't even know who I'm talking
Stop,
to.
please, stop interrupting her so
Why
we can
can't-
talk.
It's around the corner. You guys are connected parking lots. Why can't she be in here?
Okay, that's not your decision to make. So what we're gonna
Why
do
have
is,
to come to court?
you could have attended by Zoom. You wanna attend the next one by Zoom, you're more than welcome to.
No, what I'm saying is I wanna know who's confronting me. I have a right to see who's talking smack, right?
Laura Feeball, now, back to what you're saying, that's fine. When do you think you can have that, email, sent by US mail?
I will get it in by the mail by tomorrow. I'm currently emailing the staff in charge of that.
Okay,
And
excellent.
notify your witnesses that I will be wanting that to speak with them. My what's it called, Judge? What do you call it? When you talk to
Interview?
Yeah, I want to interview these guys. Make sure you let them know that.
Alright, will you make those requests in writing to the prosecutor?
Well, I just want to put it
You'll
on the
have,
record.
it's on the record, everything we say is on the record.
Yeah, exactly. That's why I said it.
So, what we're gonna do here is because you should have assuming it goes out in US mail by the end of the week, you should have it by the end of next week. That puts us at April 19th, I would say 18th at the latest. You need time to interview witnesses. I would think that by July you should be done with that, so I'm offering you let's just set the hearing date instead of August. We'll move it faster, so, cause you want speedy, so let's get it.
Well, I wanna talk about these motions first. How come you refuse to remove yourself from my
I've already
case?
asked you to state your case on those.
Well, did you? Well, I'm telling you right now. How come you're refusing to take yourself off my case?
There's a minute entry.
I can't read. I don't have glasses.
You want me to read it to you?
Yes.
Alright, are you gonna let me do that without interrupting me?
That's the only way I would be able to hear it, right?
Alright, let's go through the minute entry. This is the minute entry dated March 20th, 2025. Defendant's motion number 1, which is the request of audio and video broadcast. The court grants the defendant's request. The device used must be a handheld device and used without any other devices such as a unipod or tripod. Further, this permission can be withdrawn at the court's discretion if the court finds it is interfering or disruptive with court activities. Do you have any questions about that ruling?
No. I wanna know why you're not removing yourself from my case.
Defendant's motion number 2.
Do you think that you can give me a fair and unbiased trial?
Defendant's motion number
I
2.
think record shows not.
Change of venue. Arizona Rule of Criminal Procedure 10.3 governs a change of venue. At the hearing, the defendant requested a change of venue and the court instructed the defendant to file a motion pursuant to Rule 10.3C and provided the defendant with a copy of the rule. The defendant's motion fails to state any facts to support the general assertion that he cannot obtain a, quote, fair and unbiased trial due to Judge Roberts' practicing law from the bench and Judge Roberts' ignoring the fact that I am in the Ninth Circuit Court with superior justice in state courts.
Well, that, Your Honor, I was sick.
Finally,
So,
the defendant asserts that he has been talked down to and insulted by the courts and not given due process, referencing Judge Roberts. Judge Roberts is no longer on the bench, having retired as Precinct 10's JP. Further, the current JP has not heard any prior cases from the defendant, and the defendant has not set forth any specific facts that this court cannot provide a fair and unbiased trial. Because there are no facts to support this motion, the court denies your motion.
and I redid that, and I sent those in. Why did
I
you
have
talk
not
about the
received-
motions with your name on it, Judge?
I have not seen those yet. Defendant's motion 3 and 4, remove
Of
judge.
course you haven't.
Change of judge is governed by Arizona Criminal Rules of Procedure 10.1 and 10.2. Defendant's request for a change of judge as a matter of right is untimely and is therefore denied. Rule 10.C1A is that rule. Defendant's request for a change of judge for cause must show that this court's interest or prejudice would prevent a fair and impartial hearing or trial. That's Rule 10.1A. Defendant, however, failed to support the request with specific grounds that are supported by an affidavit. That's set forth in Rule 10.1B1. Defendant's two motions reference vague allegations without any
He's so
supporting
happy.
examples or references to the
That-
record, and reference those
Let the record
allegations.
show that the judge's smug remarks and sassy remarks on this.
And
He's
because,
so happy about screwing me over. You're a bad judge.
and because this court denied defendant's request to change venue at the last hearing, the allegations to Judge Roberts are no longer relevant as he is not on the bench. Further, this court did not deny defendant's request to change venue. Rather, the court instructed defendant to file a motion as the rule requires and provided defendant with a copy of the rule as set forth above.
And what
Please
happened to that?
defense.
And what happened to that motion that I sent you?
Defendant's request for a change of judge for cause is denied. Defendant's motion 5, speedy trial. Defendant did request a speedy trial at the hearing. However, the court has not failed to provide a speedy trial. The right to the speedy trial is governed by Arizona Rule of Criminal Procedure Rule 8 and requires a trial within 180 days. That's Rule 8.2.
Yeah, from the day that I asked for it, not when you want.
Given that this case is not close to that time limitation, the court has not denied defendant a speedy trial. Assuming all parties are prepared for a trial, the trial date will be set at the hearing scheduled on April 10, 2025 at 1:30 p.m. That's today's hearing, and I am ready to set the trial to give you the speedy trial. So,
I was asking for you, Steve. I was asking for this for day one, for you to give me a speedy trial.
and I saw you on March, that's 180 days we got to go. So, let's set it for July 18th at 1:30, bench trial.
I want a new judge. It's obvious that I can't get a fair and unbiased trial with you.
Would
I
you,
put in the motions, and I don't care what you say. I don't want you as a judge. You're the worst judge I've ever seen in my life, and I don't expect to get a fair anything with you. From the way you talk to me from the first day until all the way that you're trying to just railroad me.
and so what you're free to do, of course, is file an appeal against the rulings I've already issued, and you may do so.
I just want to see a different judge.
I understand.
Why do you refuse to take yourself off my court case when you know I won't get a fair trial?
My explanations are in my order, and if you want to appeal it, you so can. We have sent a bench trial, alright. Let's go through this just really quickly. Pursuant to Rule 9.1, if you fail to appear for a hearing,
I think that you should hold off on doing everything you're doing until I get everything that I asked for, so that way, if I can see, because what are you trying to get me for?
Rule 9.1, I'm the judge, I'm not prosecuting you for anything.
Oh,
Requires that
Yeah,
you
you're-
be present at every hearing. The failure to show up at the hearing can result in 3 things. 1, an arrest warrant can be issued. 2, you can be charged with additional crime. Or 3, if you fail to appear for a hearing, which includes the trial, if you fail to appear for the trial and the trial is held in your absence and you are convicted and not sentenced
Can I go
within
now?
90 days,
Can I go now? I don't care what you have to say. Everything you have to say is bullshit. I don't care about anything you have to say, Judge. Everything that you say it doesn't matter to me because I know you will not give me a fair and unbiased trial here. I can see it already. It's already been proven. Just let me go. If for some reason you want to keep me here railroading,
No, I'm gonna
right?
give
You
you
guys are claiming to be the victims in a lot of these cases. And
one
then,
more thing, and
What?
then you're free to go. Pursuant to.
all right, can I go now?
that
I don't
any
care what you
provision-
have to say, Judge.
Any defense.
I don't care what you have to say. I want you to remove yourself from my case.
You have
Do you
to
understand
provide a
that?
state-
You're an unfair and unbiased trial, and there's no way that I could ever get a fair. I can't even believe you're a judge. How about that?
Okay?
I don't want you as a, who do I talk to get you taken off? Since, what, I could just put in more motions now, or what?
You should go up to Superior Court and appeal the ruling I've already made. So, I've advised you pursuant to Arizona Rule of Criminal Procedure Rule 15 that any defense witnesses along with.
Are you done? Are you done?
Any defense exhibits must be disclosed to the state no later than 20 days before trial, or they may not be called as witnesses, or the.
I notice you like to stick to the sticklers on me, huh? But what, like, you know I don't have a lawyer and you're trying to come after me. I told you I want my motion. I want my discovery, because I don't even know what you guys are trying to get me with. I want my discovery. I want my interviews with the witnesses.
All right.
Other than that, I don't give a shit what you have to say. You can keep all your stupid ass opinions to yourself, and you're the wrong judge for this.
So I have issued the minute entry and advised you, all the advisories I read to you are contained in the minute entry so that you will have notice for that. And we are concluded, and with that, we are off the record. thank you all for attending.
Take yourself off my case, Judge. You're the worst judge I've ever met in my life, and it's obvious I can't get a fair and unbiased trial with you. Did you get that? You don't care. You just want to keep me
And we
here
are
so
on
you
the
can fuck
record.
me. I'm not down with that shit. I'm not down with
Thank
that.
you, Your Honor.
It's a waste of money.
You bet, you're excused, go ahead.
You're a crooked judge. I don't want you as a judge. It's obvious by the
If
way
you're not
you
going
talk.
to leave the courtroom, I'll have security
I'm looking for garbage. What do you want me to throw right here? Where do you want me to put it?
right there in the garbage can.
All right.
All set?
Just throw it right on your bench.
You don't want to threaten me.
I'm not threatening you. I said I'm gonna throw it in the trash. Is that garbage?
Gotcha.
That's right.
All right.
Take yourself off my case. There's no way. I can't believe this. Take yourself off my case. This is a conflict of interest.
Let's have security come on.
Fuck security.
Let's have.
Yeah, tell security we can suck my dick.
So tell me, what do you all think in the comments? Sovereign citizen or a citizen getting railroaded in court? I think it's a citizen getting railroaded in court. This man hasn't got his motion of discovery. He doesn't even know what he's being charged with, it sounds like. He's doing the best he can to not spend a bunch of money out of his pocket to hire attorneys and all that. Everybody knows that a public defender works for the state, and they're just going to cut deals because their job is to make the state money too. So you're kind of railroaded on that if you do take a public defender. So I don't know. I don't know what to think about this. I just know it was amazing how he talked to the judge. But you all tell me in the comments, sovereign citizen or man getting railroaded? I think he's getting railroaded, guys. I really do. Anyway, thank you all for watching. Make sure you like, comment, subscribe to the channel if you haven't. We'll be doing a giveaway when we hit 2,000. It's going to be a Black Mountain Off-Road shirt. All sizes will be available. So anyway, guys, subscribe, and I'll see you all on the next one. Take care. God bless you.